As of January 17, 2017, the U.S. Citizenship and Immigration Services, USCIS, will implement certain major changes to their employment immigration policies that may affect you as a foreign national or a business investor. Today, I'm going to discuss the highlights of these major changes and what they mean to you. Let's begin with the new grace periods for different visa classifications. For those in the E, H-1B, L-1, and TN visas, there will be a mandatory grace period of 10 days before the petition or the status begins and ends. This means that the foreign national may enter the U.S. 10 days before or after the petition or status starts and ends. The second grace period being implemented is regarding the time period after cessation of the employment, or in other words, the end of your employment. This grace period gives those in E, H-1B, H-1B1, L-1, O-1, and TN classifications 60 days after the end of their employment if the authorized stay is valid for the 60 days after employment ends. If the authorized stay is not valid, the grace period will end on the authorized expiration date. Now that I have covered those grace periods, let's look into the new Employment Authorization Document, or EAD for short. For those that fall into the category of E3, H-1B, H-1B1, O-1, or L-1 status can apply for discretionary work authorization, also known as the EAD. To be eligible for this discretionary work authorization, compelling circumstances must be shown to the USCIS, and the foreign national must have the approved I-140 petition in the EB1, EB2, or EB3 categories. Upon filing an EAD renewal in these categories, work authorization is now automatically renewed for up to 180 days once the prior EAD has expired. Additionally, these changes include that one can submit an I-797 receipt notice with an expired EAD as the permissible I-9 document, which will re-verify a foreign national's work authorization. The change to different categories of work authorization and visa petitions apply to several foreign nationals and business investors, but let's talk about a specific petitions that will see three major changes as of January 17, 2017, the H-1B. The first change to the H-1B petition is that there are exceptions to the H-1B cap, or number of submissions accepted based on affiliations with a non-profit universities. At any time of the year, non-profit organizations may file an H-1B for an employee as long as they submit a formal written affiliation with the university that states the employee will have a working relationship for the purposes of education or research. The other major change to the H-1B petition includes protection from retaliation for H-1B whistleblowers or those that report an employer violation, and the ability of USCIS to approve H-1B classification in states that permit foreign nationals to work without licensure under the supervision of the licensed personnel. USCIS will closely examine both instances carefully by investigating extraordinary circumstances for whistleblowers and examining the credentials of the supervisor of a non-licensed foreign national while making sure the employer is complying with the state requirements. The last major change I have to talk about today is that there is no longer an automatic revocation of certain employment-based immigration petitions. No longer will USCIS automatically revoke a petition if it is withdrawn by the employer or if the employer's business is terminated for more than 180 days after the new changes coming to the USCIS employment immigration policies open new possibilities to foreign nationals looking to work and invest in the United States. If you have any questions or wish to go into more details on how these changes can affect you, please seek an experienced immigration attorney for a consultation and start your employment immigration petition on the right path.